Singer Manufacturing Company versus Loog, 1882, is one of the foundational English cases in intellectual property law. Heard in London by the Court of Appeal and ultimately affirmed by the House of Lords, the case established critical boundaries regarding comparative advertising, descriptive mark usage, and the common law tort of passing off. Case summary background. The Singer Manufacturing Company had built a global business selling sewing machines, many of which relied on patented mechanical designs. After key patents expired, competitor manufacturers, including German makers represented in London by agent Hermann Loog, began producing machines based on the same mechanical principles. Loog distributed price lists and circulars advertising his machines as being built on the Singer system or Singer pattern, while explicitly stating that they were manufactured by German companies such as Frister and Rossmann rather than Singer itself. The dispute. Singer sued Loog for passing off and trademark infringement. Singer argued that it had an exclusive right to the word Singer. Using Singer in price lists deceived buyers into thinking the machines originated from Singer. Loog countered that Singer was used purely in a descriptive sense to explain the design mechanism, not as an indicator of trade origin. The advertising clearly named the real manufacturer, preventing any customer confusion or deception. The ruling, the House of Lords ruled in favor of Loog, upholding the Court of Appeal's decision. No misrepresentation. Because Loog's price lists clearly stated that the machines were manufactured by third parties, there was no false representation that the goods came from Singer. Right to describe design. Once a patent expires, competitors are legally entitled to build machines using that patented design and to inform the public that they are built according to that system. No monopoly over. Descriptive words. A trademark owner cannot prevent others from using their name in an honest, purely descriptive context to indicate compatible types, models, or mechanical systems. Key implications for trademark law. No man is entitled to represent his goods as being the goods of another man. Lord Justice James, quoted throughout UK passing off jurisprudence, Singer versus Loog shaped modern trademark law in 4 major ways. 1. Foundation of the tort of passing off. The case solidified the core principle of passing off. Misrepresentation as to origin, not merely the unauthorized mention of a competitor's name, is the essence of the legal claim. If there is no likelihood of public confusion or deception regarding who made the product, there is no passing off. 2. Standardizing honest descriptive use. The ruling established that traders have a legitimate right to use a competitor's trademark descriptively. This laid the groundwork for modern nominative fair use and descriptive use defenses, allowing companies to state things like compatible with X or built on system Y without infringing the original mark. 3. Early framework for comparative advertising. By permitting Loog to refer to Singer in price lists to explain product specifications, the judgment established early judicial acceptance of comparative trade practices, provided they remain honest and non-deceptive. 4. Preventing patent-to-trademark monopolies. The decision addressed the overlap between patents and trademarks. It prevented companies from using trademark law to effectively extend a patent monopoly indefinitely, ensuring that once a technical mechanism enters the public domain, the common descriptive terms for that mechanism can be used by competitors.